Hello students, this is Dr. Rajamogli Amrishetty, practicing company secretary, corporate legal advisor and insolvency professional. Being an insolvency professional, I am also handling certain insolvency processes and liquidation process of certain companies. I am also author of a book on lectures on insolvency and bankruptcy laws. Thus, I am confident to properly elucidate this topic and I am glad to be part of this knowledge sharing mission. In the previous lesson, we have covered genesis of insolvency and bankruptcy laws, objectives and scheme of the code. But in this lesson, we will cover salient and important features of this code, issues and challenges in implementation of this code, important salient features of IBC. One of the feature is that default in payment. Please understand the financial market process. What happens? There is one lender who is called, if it is a financial institution or a bank, is called financial creditor. He lends the money, thus is a financial creditor, and the person who borrows the money is the borrower, or if it is a company, it is called corporate debtor. And there are also in the market certain persons who supplies the goods and services. They are called operational creditors. Now, let me say there are two types of the creditors, that is financial creditors and operational creditors. Who does some service and who lends money to the companies, they are called corporate debtors. Now, this bankruptcy code harmonizes the process of insolvency, restructuring, rehabilitation and the umbrella of corporate insolvency resolution process. Now, point is that once either financial creditor lends money or the operational creditors supplies the goods and services, and if the borrower fails to pay the money or fails to pay the money to the financial creditor or fails to pay money to the operational creditor, then the trigger for this IBC arises. Now, what is the criteria, what is the amount which should be taken as the criteria to trigger this code? If the corporate debtor borrower fails to pay 1 crore and above, the financial creditor or the operational creditors will make an application to recover that amount from the corporate debtor. Once he makes an application to the adjudicating authority, the process of corporate insolvency resolution process starts, that is called CIRP process. So, now once the CIRP process is made to the adjudicating authority. Now, second feature of the code is adjudicating authority. Now, these adjudicating authorities for the purpose of expediting the economic market recovery, now separate adjudicatory system is established. One is National Company Law Tribunal. Once it receives an application by either the financial creditor or operational creditor, or sometimes the company may also make an application saying that I am not able to pay debts to the people, therefore, admit me for the CIRP process. So, once this application is received, either of application from either of these parties received, then the adjudicating authority, that is NCLT or DRT in case individuals and partnership, they will appoint interim resolution professional, is called IRP, and the adjudicating authority, after appointing the IRP, simultaneously it announces the moratorium as well. Moratorium in the sense it fixes an embargo against the institution for any proceedings or suits to be filed against the corporate debtor, because he has become a sick, so or is in certain process. So other people should not disturb that until this process is decided, that is called moratorium. So, then now these adjudicating authorities have got wide teeth and power. Now, there are about 16 national company law tribunals in India operating as adjudicating authorities, and there are 2 NCLATs, National Company Law Appellate Tribunals, one at Delhi, other at Chennai. The NCLT once appoints the IRP, that is interim resolution professional or a resolution professional, then he will proceed and constitute committee of creditors. This committee of creditors plays a vital role. It is called as COC, which includes only financial creditors. Operational creditors who are having 10% of aggregate exposure, they will only be there as observers in COC. They do not have voting power, they will come and sit there, but entire thing is handled by the financial creditors. The COC, that is committee of creditors, is responsible for deciding the important affairs of the company. They are like earlier board of directors. Once the IRP is appointed, board of directors get suspended and COC helped by the RP, resolution professional, will continue to operate the company, because very important object of this IBC is not to liquidate the company immediately. Unlike earlier processes, very important object of this IBC is to revive the company. That is why it is divided into insolvency and bankruptcy. First, the object of the code is to revive the companies. That is the primary objective of this IBC. So, then the COC will take control of this IP and it directs the IP to what to do and what not to do. More importantly, the COC may approve resolution plan submitted by the insolvency professional. That is how the insolvency professional does all the work. He submits the plan to the COC. COC may consider that in the resolution plan and may recommend to the adjudicatory authority to approve it. So, this is the important process and structure in the IBC. Now, friends, there are certain issues in implementation of the things. Now, of course, there are also certain provisions, this cross border insolvency. As you know, once the company is formed and there are a lot of issues, because the company which is incorporated in India may have their subsidiaries outside the country, and some of the companies which have the operation of registered office in other countries may have subsidiaries in India. So, once the insolvency process is initiated against the corporate debtor, having operations in various countries, how to recover the money in other countries is the issue. So, that is how the cross border insolvency provisions. Now, at present there are two sections, 234 and 235 under the IBC. One being the central government entering agreements with other countries for enforcing the provisions of the code in such countries, and the other being the adjudicating authority having power to write to the courts and or authorities of other countries for seeking information or requesting action in relation to the assets of the debtor situated in outside India. Now, this property what I am referring has got a wide connotation. Property under the code includes money, goods, actionable claims, land and every description of the property situated in India. Now, the provisions, whether this 234 and 235 IBC are comprehensive or not, I will deal subsequently. The other important part of this insolvency and bankruptcy code is that there is a dynamic change in the system. In the existing system, what happens? Once the company borrows the money from the financial institutions, the borrower, that is the debtor, runs the business, that is called debtor in possession. Debtor who borrows the money from financial institutions continue to run the business, but they are none but the promoters acting as directors, etc. Once the debtor fails to successfully run the company and unable to pay the debts, then the creditor who lent the money to this borrower, that is the debtor, he takes the control. That is one of this concept is not there in earlier legislations. Now, getting the creditor in possession is a fundamental shift in the provisions of this act. So, that is how it is one of the important characteristics of this IBC. Now, in the IBC, the other feature is there are 4 pillars of IBC. These 4 pillars sustain or make the code successful. One pillar is IBBI, Insolvency and Bankruptcy Board of India, which is important regulator. It is functioning more effectively than other financial regulators. Other is IPA, Insolvency Professional Agency. and insolvency professionals, which is very important, factor, very important pillar of the IBC, and information utilities. And these are the main 4 pillars of the IBC. Now, there are other important feature is information utilities. These information utilities plays a very important role in expediting the process of resolution. They store the information and provide the information to the adjudicating authorities and IPs, insolvency professionals. It is a very good system on par with the UK and other developed countries. Other important feature is individual insolvency. This individual insolvency earlier dealt under the age-old legislations, that is Provincial Insolvency Act and the Presidential Insolvency Act. They are 1909 and 1920 legislations, and these provisions were ineffective and not able to control the insolvency regime of individuals. Part 3, which regulates the individual insolvency, and of course, as I said previously also, part 3 is not enforced yet. And once this part 3 is enforced, the jurisdiction to deal with individual insolvency will lie with the DRT, Debt Recovery Tribunals. The other important feature is inability to pay debts to default in repayment. It is significant to note that the IBC aims to shift from the sickness test coined under SICA, Sick Industrial Companies Special Provisions Act, under chapter 19 of the Companies Act, which now stands repealed, to the cash flow test, allowing for more objective standard of evaluation. Either inability to pay was a trigger to file winding up petition. Now, the trigger is default. Inability to pay is not the question, which was the test earlier. Now, jurisdiction and appeals. Now, this is another feature. The National Company Law Tribunal and Debt Recovery Tribunal are the 2 important adjudicating authorities which are constituted to expedite the process. Now, other important feature is proportionate voting power. Under the code, each financial creditor of COC, whether secured or not, gets to vote on a resolution plan of the corporator on the basis of its voting share, proportionate to the money advanced by the creditor. Why I am saying this is, as a matter of fact, the secured creditors are the persons who got more right, but they are also given equivalent power on par with the unsecured creditors. Other thing is penalties and punishments. There are stringent penalties and punishments laid down under the Act in this economic legislation, which is very important feature for effective implementation of this code. Now, timelines. This is also very important feature of the legislation. Here, timelines are started or begins when the IRP is appointed, right. There is a process is laid down, and the maximum number of days within which the process ought to be completed is 330 days. Our important feature is waterfall mechanism for distribution of debts. Friends, once the company is unable to pay debt, or it fails in the liquidation process, it fails in the insolvency process, it is declared to go for liquidation. Once it goes for the liquidation, the assets of the company are sold. Once the assets of the company are sold, how to distribute that money, it is determined under the waterfall mechanism. First, it ought to be paid to the workman dues of preceding 24 months, then the employee dues of preceding 24 months, and secured creditors, unsecured creditors, and thus government dues stands at the last. This is one important the future, where the government dues are given less priority than the workman dues or the secured and unsecured creditors. And this code also consolidates several acts, they are like Provincial Insolvency Act, Presidential Insolvency Act, SICA, all these acts are consolidated and made as code. I was emphasizing that when many of the acts are consolidated, it is termed as a code. There are lot of key issues and challenges in implementation of this code. One is no timeline for disposal of adjudicating authority or appeals at the appeal level. Now, once the matter is filed with the adjudicating authority, though timelines are prescribed at the insolvency resolution process, liquidation process, no time limit is prescribed for disposal by the adjudicating authorities or appellate levels. That is how most of the processes are expedited in the beginning, and when it goes to the adjudicating authorities, they are pending there. So, this is a concern under the Act, and other concern under the Act is lack of consensus amongst the lenders. The code vests lot of powers on the financial creditors as they form the committee of creditors. As I said, the operational creditors are not given importance. So, and amongst the financial creditors also, lack of consensus and willing to cooperate on part of the financial creditors could be detrimental to achieve the concerted results. Thus, an implementation of the code is foremost dependent on the COC. If the intention of the COC is not focused for revival, the process would remain merely a procedure to quantify the assets and minimize the provisions as bad debts or contingent assets or receivables. Other important feature is dilution of rights of secured creditors. As I said, in the waterfall mechanism, the secured creditors gets the priority if company goes into liquidation. Therefore, secured creditors and unsecured creditors got same rights of voting, as I said earlier. Now, thus there is a dilution. Secured creditors will not cooperate, and they always say that we are the first person to receive the thing. So, we should have more power. So, there should be some system to enable secured creditors having more powers. And the other concern is challenges in arranging the working capital requirements for day-to-day operations. The IRPs or resolution professionals are not able to borrow the required working capital in order to run the business as a going concern. Now, friends, as I said, the very important objective is to first revive the company. To revive, the IRP sits there, and to run the company he needs some money towards working capital or day-to-day finance. So, when he approaches the bank or the financial institutions, they will not lend the money under the fear of liquidation. The company is anyhow going to liquidation, why should they lend the money? They are not giving the money. Now, let us see the fear of liquidation as a major cause of concern. Once CIRP is initiated, the employees in the company and in the market, the company is branded as something which a company goes into liquidation. So, this may lead to employee attrition, loss of business and lack of support from vendors, leads to loss of confidence or cooperation from the employees, vendors and customers. This is causing a concern for the companies to revive, because the other persons in the market may not cooperate or may not support the process of CIRP. So, there should be a separate system like venture capital system to fund these this type of the companies. So, therefore, it enables the RP or the COC to borrow money to run the day-to-day affairs of the company. Another important lacunae or the factor that is effective implementation of the IBC is difference between operational creditors and financial creditors. These operational creditors are not given equal rights. Operational creditors who have got 10% of or more control may be parties in the COC. They will just come as observers, they do not have a voting right. So, there is a complaint always by the operational creditors that we are not given power and we are also persons having control over the company. So, there should be some mechanism to give weightage to the operational creditors. And other thing is overhauling of DRTs. Debt recovery tribunals, as I said, will exercise the jurisdiction once the individual insolvency is given effect to. So, these debt recovery tribunal as on today do not have proper infrastructure. They should be properly restructured to handle the part 3. Part 3 is, as I said, is not implemented, but once it is implemented, the existing infrastructure is not adequate. So, there is a need to restructure the existing infrastructure of DRTs to enable to handle once the part 3 is enforced. Other important factor is cross border insolvency. Once the company is incorporated, they may own certain assets in other countries. Certain other countries, companies may have the foreign company status in India. So, even though the code suggests mechanisms concerning the cross border element of the insolvency and liquidation, a comprehensive framework need to be imbibed to effectively deal with this issue. Numerous Indian companies have assets and creditors situated all over the world, and at the same time various foreign companies have subsidiaries in India. Given the increase in foreign investments into India in the recent past, the impact of Indian laws that affect business ought to be reviewed in conjunction with the laws of other jurisdictions. In this context, I suggest for adoption of ancestral model law on cross border insolvency, which is required. Ancestral model is the common law for the various countries. Then only effectively these cross border insolvency processes can be implemented. The issues relating to insolvency liquidation of Indian companies with assets located in several jurisdictions outside India and vice versa cannot be achieved without having a mechanism like adoption of ancestral law, model law on cross border insolvency. The existing system of bilateral arrangements, as I said, section 234 and 235 is not effective, as it takes a very long time to negotiate an agreement with each country, and as per the existing provisions, upon the receipt of letter contemplated on the code, foreign countries may refuse to share any information about the assets located in their countries. So, therefore, once the ancestral law is enforced, it is easy to implement the cross border insolvencies. I would like to emphasize recent past, many companies having assets in other countries, once they go into liquidation, they are delayed, like companies like Island FS, Jet Airways and many other companies, the process is delayed more than 2 years and 3 years because of the lack of provisions of the cross border insolvency. So, there is a need that ought to be thought to have proper cross border insolvency processes, and also group insolvency. A group will have lot of companies, subsidiaries and also the companies in various other countries. So, to handle the group insolvency, separate provision ought to be provided to handle the group insolvencies, so that there will not be much delay. There are certain guidelines, but which are not proper, not effective to handle the present scenario, and therefore, there is a need to amend the insolvency and bankruptcy code to cover the group insolvencies. These are the important features of insolvency and bankruptcy code and causes of concerns for effective implementation of insolvency and bankruptcy code at present. And these concerns, what I expressed, need to be addressed so as to have an effective implementation of this IBC. Thank you, students. In the next lesson, we will discuss about the insolvency resolution and liquidation for corporate persons, that is companies and limited liability partnerships. Thank you.